Hi, it's Jackie Broman here from TBA Law. This is a presentation that I've given at a number of different places, and I thought I would record it here so that it's online for anyone who wanted to look at it. About some general estate planning tips, tricks and myths. But firstly, I always in this presentation talk about what a lawyer actually is, because a lot of people even ask. A lawyer includes a solicitor and a barrister. They're both lawyers. I am a solicitor. Solicitors are the ones who tend to work in the community directly with clients. Solicitors then subcontract barristers to do certain work. It's very rare for a barrister to work directly for a client. There are lots of areas of the law, and it's continuing to get more complex, and particular areas of the law have lots of changes in them all the time. So it's becoming less and less likely that your solicitor will be a generalist. They will often know a few areas of the law, but don't expect a lawyer to know everything. So succession law is one of my particular areas, along with property. Succession law covers personal succession, so doing your estate plan, business succession, which is structuring of businesses and exit plans for businesses, the whole probate process, and then estate and trust administration. If you pass away without a will, it's what is called intestate. Now, no, the government doesn't get all your money if you don't have a will. However, the legislation does have an order in which who gets what if you don't have a will, and it's not necessarily the order that you would think. If you're married, for example, and have children, you would think that everything would automatically go to your spouse. That's not the case. In fact, if you have a spouse and children, your spouse gets the first 100,000 plus the household contents, and then only a third of the balance, and the remaining 2/3 get split between your children regardless of their age. If you don't have a spouse or children, your parents are next in line. If your parents have passed away, your brothers and sisters, then it goes out further to nephews and nieces, and only then does the government get it if there's no one on the list that's left. Superannuation. It's most people's biggest asset these days, and superannuation is not an asset that is passed under your will. It is an asset that's held under a contract that you have with the trustee of your super fund, and that's why you need to tell your super fund what you want done with your super. There's only certain kinds of people that you can leave your superannuation to. They are called superannuation dependents. These include your spouse, your children, anyone who's financially dependent on you, or your legal personal representative. These are the only people you can directly leave your super to from your super fund. If you nominate any other people outside of these categories, it is not valid. If you want to leave your super to your parents or your siblings, for example, you need to nominate your legal personal representative and then do a will to make sure that the superannuation goes how you want it. The other aspect with super is that it's not necessarily tax-free. It's tax-free to certain dependents, but not others. So if your spouse gets the superannuation, they don't have to pay tax. If children who are under the age of 18 get superannuation, there's no tax. But if your children are all over 18, then they will pay tax. They will pay it on their own income tax return at their marginal rate. And this won't necessarily be equal, obviously, because your children don't necessarily earn the same amounts. When you nominate with your super fund who you want your super to go to, there are binding nominations and there are non-binding nominations. Depending on your situation, either of these could work for you, and that's something to work through with a solicitor. As well as wills, powers of attorney are crucial parts of your estate plan. A will begins once you pass away. However, a lot of people either have diminished capacity or they have an accident and are in hospital for a period of time before they pass away. So, powers of attorney usually begin when you've lost capacity. However, you can have your financial power of attorney begin immediately. The law has changed slightly since I prepared these slides, and instead of 3 types of enduring powers of attorney, there are now only 2. The financial and legal power of attorney and the guardianship power have combined into one. So there's only a medical power of attorney now, and your other enduring power of attorney, which covers everything else. You can also do a general power of attorney. Now, this is not enduring, which means that it doesn't last after you've lost capacity. You'd only do a general power of attorney if you were, for example, going overseas and you had a purchase or a sale of a property going on and you'd want someone to finish that off for you. All right, so these are some funny little rules that exist in the succession law space. So, in a couple, if you and your spouse were to die together, the law deems that the younger of the two of you died second. So this is why most spouses have mirror image wills, because they don't necessarily want, for example, if the younger spouse had a different will to the older spouse, the family of the older spouse could miss out. So they generally need to reflect each other. The purpose of this is because, like with the 30-day rule, which is also on this list, someone needs to survive you for 30 days to inherit. So if you die at the same time, we don't want to be transferring assets from estate to estate. The forfeiture rule. This one means that if someone kills you, then they can't benefit under your will. So if you're worried about a spouse or a child knocking you off for your life insurance, if they did that, they would miss out on the lot completely. The gift over to children is an interesting rule to make sure that parts of your estate don't become intestate accidentally. So the law prefers that if people take the trouble to do a will, then it means they didn't want to be intestate. So if you leave everything equally to your children, but one of your children happens to die before you, we don't want that portion to become intestate. Instead, it gets passed down to the children of your children automatically. With residue, a similar rule actually to gift over to children. If you divide your residue up in percentages or shares rather than just saying equally to my children, you might say 50% to such and such, 20% to such and such, and 30% to such and such. If one of those people dies, the law says that the balance gets divided proportionally between the survivors. So that is another rule to prevent intestacy. The last 2 topics are just some legal jargon really. So there's a difference between a specific and a general gift. A specific gift is I leave my jewellery to such and such. But a general gift is I leave 500 Commonwealth Bank shares to such and such. Now, with the specific gift, if I didn't have jewellery anymore when I died, then that gift fails. But with a general gift, I may never have owned any Commonwealth Bank shares, but the estate has to buy those shares to make that gift. And then the final point, classes of and specific beneficiaries. So obviously we can be specific about who we want to get something. We name them in the will. That's easy enough. That's a specific beneficiary. A class of beneficiaries is when we say my children or my grandchildren. So that class is whomever is alive at the time that falls within that category. Hence, if you're a young family, you might say, I leave everything equally to my children, because you might intend to have more after you've done your will, and you don't want to name them all. You want them all included. Likewise with grandchildren. These are just some crucial roles in your will. The executor is obviously very important. It's the person who collects in your assets and administers the estate and then does the distribution. So it needs to be someone who is trustworthy and capable. The guardian, if you have minor children, you really need to think about who you want your guardian to be. You should also have an alternative guardian just in case. If you appoint your best friend as your guardian, it might be conditional on them being in a stable marriage. And if that marriage breaks down for whatever reason, you have a backup, because you don't want your children going through a divorce. And then a trustee. So generally, the executor would become the trustee if the estate was being held for any particular time. However, this doesn't have to be the case. You could, for example, appoint a combination of your executor and your guardian to look after your inheritance for your minor children until they can get it. There are many different combinations or appointments that you can make, so it's worthwhile having a good think about these important people in your estate plan. And finally, my message in this presentation is that you should take control. You're working hard during your life. You shouldn't just leave everything you've done at the whim of the law. Do your estate plan. Take control of your assets and what will happen to them while you can. Because when you're sick or unwell or you've had an accident, it's too late. So on that morbid note, if you need to contact me at any stage, visit my website at tbalaw.com.au. All my contact details are there, phone numbers, email addresses. There's also plenty of free downloads. Or you can reach out via our Facebook page, or you can find me on LinkedIn. Thank you very much for listening.